I'm Aline Swafford, President of Prosperity Partners Wealth Management, and I am really excited to bring to our forum today Samantha Paris. Samantha and I have known each other through the Knoxville Estate Planning Council. Samantha is an attorney focusing on estate planning. She does wills, she does trusts, she does probate and conservatorship. And certainly in these very trying times where many people say, am I prepared? Is my family prepared? There are some issues dealing with estate planning that we need to deal with. So Samantha, we're going to have just a great conversation, and you just share with all these great folks your wisdom on these particular areas. We're going to start with, well, what's the importance of having a will?
Well, first off, thank you so much for letting me join you and talk to all these wonderful people today. I certainly appreciate it. To answer your question, the importance of having a will is that it gives you the power to decide what happens to your assets when you pass away and who you want to put in charge of making that process happen. So it takes the decision-making power out of the hands of the government and puts it back in your hands.
Well, I think most of us like to have control if we have that option. So tell me, what happens if you die in Tennessee without a will? What's going to happen to your assets?
If you die in Tennessee without a will, the state of Tennessee has written a will for you already, and that's called the law of intestate succession. So who your property is going to go to is going to depend upon your family structure. For a lot of people who are married with children, it would go to your spouse and children together. That sounds like what a lot of people would want until you think about, well, if there's a minor child, they can't own property. So that becomes very difficult handling that property. In addition, if you don't have close family members, it can mean that your estate is diced up into a ton of parts. For instance, I once had an estate that was split into 154 shares and went to people who had never met the lady who passed away. And I think one of them got like a check for $16. So it can sometimes end up in a ridiculous result.
Oh my gosh. And I think most people who are married just assume that everything they had would go to their spouse. That doesn't work that way from what I'm hearing from you there. Is there some share that everybody gets, or how does that work?
Anything that's in your name only would go 1/2 to surviving spouse if you have one kid and 1/2 to the child. If there's more than one child, 1/3 to the spouse and the rest split between the children.
All right. Well, right there is a big reason why a lot of people would say, now, wait a minute, I've been in this for 25 years with my spouse, and I certainly think he or she should be thinking about me.
Mm-hmm.
And so there's a good reason. What about if you own a home and you don't have a will? Are there any complications with that?
If you don't have a will and you pass away owning a house in your name only, it can really cause your heirs to experience a delay when they try to sell the house and divide the proceeds amongst themselves, or if someone is wanting to maybe refinance your mortgage and live in the house themselves. Dying without a will makes that process take longer and be more complicated, either with the title company or the mortgage company.
Well, that sounds like that could be a mess.
Yeah, well, and a lot of times what happens is the title company will approve the sale, but then they'll hold the proceeds for many months. And so, that's a big delay.
Absolutely. And that's not what any of the heirs are looking for, particularly if they're trying to sell the property and divide the assets and move on with their lives.
For sure. Nobody comes to me and says, I want a delay in getting my money. That doesn't happen. I assume that doesn't happen with you either.
No, not at all. What about a handwritten will? Are there any complications that could take place if you just wrote out your own will?
So handwritten wills are legal in Tennessee. So you can technically write one out yourself. Just like technically I could rewire the electrical in my home all by myself. Now, realistically, there's going to be some problems with that because I don't know what I'm doing.
Right.
So often that leads to problems where people don't know the specific legalese that needs to go into a will, or they don't provide what happens to all their assets. Another big problem we see is people hear handwritten will and they type something up on the computer, print it out, and sign that. That is not a valid will. It has to be all in your handwriting. We're just in modern times not used to handwriting a bunch of stuff, all long form, which also leads to the problem of witnesses. You have to have two witnesses who will attest that that is your handwriting. And a lot of times, you know, we have old big letters from people that they would write. Sometimes it's harder to find those witnesses now.
Sure, sure. As people are moving all over the country. So here you thought you had a valid will and nobody can attest that you really do.
Yeah, so
So
I always advise that they get that done by a professional.
exactly, exactly. I think most all of us would agree that trying to be your own electrician, trying to in these times cut your own hair,
Oh, goodness.
certainly trying to write your own will. Whew, none of those are things that probably any of us need to experiment with. This is not a time for experimentation.
I think we've all seen the videos of the at-home haircut fails. I think you're
Oh,
exactly right.
I've seen some poor pets that really got butchered as well with their summer haircuts.
Yes.
So besides the will, Samantha, I know that there are other documents that folks need, and some of those are really important, particularly during this coronavirus, I'd say.
Yes, so two other really important documents are a power of attorney and an advanced care plan. So your will says what happens to all your property after you die. These two documents appoint someone to make decisions for you while you're alive, but unable to communicate your wishes. So you'll see them used a lot to plan stuff out for people. Everyone should have one. They're used more for people who have like mental deterioration diseases like Alzheimer's or dementia. They're also used when someone has a sudden accident, such as a car wreck, and they're unconscious and can't communicate their wishes. Or right now, if they suddenly take a turn for the worse with, say, COVID-19, we can have that information about what they wanted to happen with their care and who they want making decisions for them in both their business and healthcare realms.
Excellent. So again, really important things at this particular juncture. And again, people all or I have heard them say a lot, well, I'm going to have my oldest child be, a certain aspect of my estate plan. Is that recommended? Do you do it by basis of who's the oldest child in the family, or how do you make these decisions?
Well, I am the oldest child in the family, so I think older children are great, and at least in my family, should make all the decisions. But the better course of decision making is to set someone who's good at both business and medical decisions. Like, for instance, I have told my parents, don't make me your healthcare power of attorney because I don't want to make those decisions. My sister's in the medical field, let's get her in there, have her make those decisions. It should be who is best suited for the job. And if you're choosing between someone who's located locally to you and someone far away, I would go with the person who's local to make those decisions.
Yeah, and sometimes, Samantha, I've heard, for example, you mentioned your sister. People will say, well, let's just have both my children. Does that work out?
Well, me and my sister get along great, but if we were to disagree and just the two of us were on there, there's no tiebreaker. So ideally, you would have just one person. I will do two if they get along really well and make decisions well together, but it's not the preferred for me, just because I've seen it go wrong so many times. Because these decisions aren't made in any time but a high stress situation. People are emotional. it doesn't bring out the best in people always.
I would certainly agree. What about if you pass away and your will says give all my assets to my current spouse, but the 401k lists your former spouse as the beneficiary? Who gets the money?
Well, you're about to have a very happy ex-spouse because they're going to get that money. Beneficiary designations override what your will says. That's why it's so important for people to meet with experienced financial professionals such as yourself to review those beneficiary designations, both with accounts they have with you and any other accounts they may have. We also see problems with that when people get a new job. They're first starting out, they're young, they're unmarried, don't have any kids. They put mom and dad down as a beneficiary. Then time goes on, they get married, have kids, they never change those beneficiary designations. So it's very important to have a trusted financial professional partner who will look out for your best interests and make you look at those every now and then.
Right. And another thing I know in our practice is we want to make sure that people have not only a primary beneficiary, but a contingent, a second beneficiary. So should something happen to that primary beneficiary, it doesn't end up just going into the estate and having to be probated if it could have gone directly to the beneficiary.
That's
Another
very
thing
true.
we see is lots of times, and you need to check with different companies, but people will not use the Latin per stirpes and they have children. Have you ever seen an estate where grandchildren just got cut out?
I've seen that, and I've also seen stuff where again they don't have a financial professional like you to work with, and they have one kid and they never go back and put the second kid down as a beneficiary. Or same thing with one of their kids has a grandkid, and so they put that one down, and then they never update it for the other grandkids.
Right.
So that's why it's so important to have someone who can, kind of remind you to do those things and to do other important things that I always preach to my clients, like at least look at the concept of long-term care insurance. And that's insurance that would pay for care in what's called a nursing home, assisted living, or hospice should you need that care. And I know you talk with your clients about that as well.
Right. Also, most all of these policies cover home health care too, because if you
Oh,
talk to folks and you say, where would you like to be taken care of? There are very few people that would say, oh, I want to go to a nursing home. They'd say, no, I want to stay in my home, but we do need assistance. So, of course, I think that's an important part of it. And today, things have really changed. Often we've heard people say, oh, long-term care, I've heard it's so expensive, and I've heard these companies just go up every few years. I just don't think that that's something that's appropriate for me. And there are now some very creative solutions out there, combinations of life and long-term care. So it could be used for somebody in your family, for you if you needed it, or of course for your heirs. Same thing with some old annuities. Sometimes people have those and they say, gosh, I just really can't, I don't know why I bought this. It was great when it was growing, but now I understand there's going to be a lot of taxation. Well, there are now programs out there for long-term care where you can get an annuity and do a swap called a 1035 exchange, where that old annuity, now all that growth could be used for long-term care in the new annuity without any taxation. And death and taxes, I don't think anybody likes either one of those topics. So certainly something to be looked at, not only in these stressful times, but in all times. Good planning never hurts. And so again, there's probably some other things, Samantha, that you could say, here are some things that I've seen in my practice that have kind of caught people off guard. Does anything come to mind?
And another thing I see people be caught off guard with is if they have a beneficiary who is on disability,
Oh,
um, leaving that person money if they're on certain types of disability can knock them off those programs. So it's important to talk to a lawyer who can structure things, perhaps in a special needs or supplemental needs trust, so that you don't inadvertently harm your beneficiary by leaving them property.
Right.
And then I guess the last area I say trip up people is if they have real estate in multiple states. In that situation, you probably want a trust, because otherwise, if you own property in multiple states, you're going to have your estate probated in all of those estates, which is going to be much more expensive for your heirs. So that'd be a great time to talk to your attorney about a revocable trust for you.
Okay. Excellent point. I know one of the things that you had mentioned is conservatorships are one of the things that you do.
Mm-hmm.
Tell folks a little bit about that, and are there ways that maybe they could make sure that they don't end up in that conservatorship scenario?
Certainly, yes, I do a lot of conservatorship work, and quite frankly, most of it is very sad, because we're dealing normally with someone who is in a nursing home who has advanced Alzheimer's or dementia or a similar disease, who's unable to make decisions for themselves. And because they've never had someone prepare a power of attorney for them to appoint a person to make those decisions, we end up going to court to figure out who would be the best person to make those decisions. And often they'll have to go on the stand and be cross-examined by me, questioned by their lawyer. We have to look into their healthcare records. It's just not somewhere that you would want to be. So it's really important, if you go ahead and get that power of attorney done, then as long as you don't revoke it, you've already let the court know who you want to be your decision maker, and we can use that power of attorney.
Samantha, do those powers of attorney ever expire? I know sometimes when we're working with financial institutions and people really have tried to do the right thing,
Mm-hmm.
they'll say, no, I need a power of attorney that's dated within the last 6 months or something like that. Is there any rule about that?
Well, in Tennessee, there's not. So theoretically, you could do one power of attorney and it never expires unless you yourself revoke it. The problem comes when we're dealing with, like, say, a bank that's based in a different country or state that might have different rules. So we can run into that problem. We're always, with my clients, we'd be glad to have them come in and execute a new one if they need it, as long as everybody's competent to do so.
Okay. And, you know, we have such a wonderful place to live here in East Tennessee that we're attracting a lot of folks. Many of those folks either have a will or trust that was created in California or Michigan or New York or something like this. What do these folks need to do, Samantha?
They should have a Tennessee lawyer look over their documents to see if what they have complies with Tennessee law, and also if there would be a better way to structure it. Just because it might comply with Tennessee law doesn't mean that it is the best for their circumstances now. Say, for instance, if they have a will that's great in New York, even if it's good here, they may need to go to a trust if they still own property in New York and own it here. So it's always just good to, I call it like a checkup, like going to see your doctor and having your documents checked up on, basically, is what I suggest.
Exactly. Well, I think that's true. I think checkups, whether it be with your attorney here in Tennessee or with your financial advisor, make sense. We now seem to have probably more time on our hands. I've had folks say, well, I've cleaned out the attic and the basement and the garage, and I say, well, now wouldn't it be a good time to clean out some of your financial documents to really see what do you have, where is it located? We've had people even not know the passwords to somebody's phone or their computer, and you could have done the best job possible with some of our financial instruments, but if people don't know you own them or don't know where to find them, that can be a real dilemma. So I'm sure that would be your advice as well, as there's no time like the present.
There's no time like the present to get this done. And if you already have it done, to review it and to tell your children or your spouse or whoever your heirs are that you have a will and where it is. So when the time comes, they can find it. There's no point in doing this and then hiding it away for no one to ever be able to find.
Exactly. Exactly. Well, I think you've given us a really great overview of some of the things that we all need to be aware of, look out for, update, and planning, as always, is one of those things that we hope you'll either call Samantha Paris directly at her firm, call Prosperity Partners Wealth Management. We'll be glad to connect you. But as planners and financial professionals, we hope that everybody has the services of great attorneys such as Samantha. Thank you for joining us today, and thank you for your insights.
Well, thank you so much for having me.